We're going to start recording. Right. I wanted to welcome everybody to the Women Veterans Alliance webinar. I am Melissa Washington. I am the CEO and founder of Women Veterans Alliance. And if you're not familiar with our organization, we are a nationwide organization with our mission is to connect women veterans with each other and women veterans with resources. And one of the ways that we do that is with our partner webinars, which is today with the EEOC. With that, if you're not connected to us on social media, we are on Facebook, Twitter, Instagram, Pinterest, LinkedIn, and YouTube. And that's where this video recording will be, as well as previous webinars. And if you're interested in becoming a Women Veterans Alliance member, we do have women veteran memberships as well as non-women veteran memberships available. We do have a promotion. If you're interested, feel free to email me and I'll share that information with you. But these webinars are provided at no cost. If you haven't heard, we have launched Women Veterans Alliance Magazine California edition. We are in the process of launching several other states. So if you are in Texas, Florida, DMV area, we have extended our deadline for advertising as well as photos and articles. So if that's something of interest, and also too, if you're interested in bringing the Women Veterans Magazine to your state, please feel free to email me and we can share a little bit more information on how we can bring this yearly publication to your state. Our upcoming events. So we've got some great things happening next month, which is April. Next Wednesday, we have a business, personal, financial literacy and entrepreneurship. We also have on April 20th, how to ask for exactly what you want and get it by thinking like a negotiator. That is a must not miss webinar. And also on April 27th, we have the Partnership Advantage, a business strategy for growth. And with our nonprofit partner, Women Veterans Giving, we have a night of laughter. It's going to be an online comedy show. There's no cost. Of course, a donation can be made. And that is going to be the evening of Thursday, April 28th. And you can go to the bit.ly/WVG comedy. And then for any of our other upcoming events, our webinars and anything else, you can visit the Women Veterans Alliance website for that information. So without further ado, I want to get everybody introduced to our presenter, who is from the EEOC. And the topic today is about disability, veterans, and the EEOC. So I want to introduce you to Rogelio A Colón. Was born to Mexican and Puerto Rican parents in El Paso, Texas. He is a second-generation Hispanic-American whose grandparents hail from northern Mexico and the central mountains of Puerto Rico. Since both of his parents were serving in the U.S. Army, he was a classic military brat and grew up in places such as Georgia, South Carolina, Texas, Oklahoma, Germany, and Puerto Rico. Motivated by his parents' example of military service, he enlisted in the Puerto Rico National Guard and attended military police one-station unit training at Fort McClellan, Alabama. Soon thereafter, he went on active duty and he was stationed at Camp Casey, ROK, Fort Myer, Virginia, Schofield Barracks, Hawaii, and Fort Lewis, Washington. He completed his tour of service in 2003 and subsequently joined the Department of the Army as a civilian. In 2009, he joined the U.S. Equal Employment Opportunity Commission as an investigator and is now an outreach and education coordinator for the EEOC's Las Vegas local office, as well as the Honolulu local office. He is married with 3 children. He graduated from Colorado Technical University with a Bachelor of Science degree in Criminal Justice and from Liberty University with a Master's degree of Divinity, Chaplaincy. He is now working on a doctorate degree. So without further ado, I would like to introduce all of you to Rogelio.
Melissa, thank you so much. I appreciate the invitation. It's an honor to be with all of you today. Allow me to share my screen. I just want to have a conversation with all of you about disabilities, veterans, and the EEOC. Give me 1 second. Let me share. Okay, so my name is Rogelio. At any point during this conversation, you have a question, you can drop it in the chat. You can send it over to Melissa. I'm not quite sure what the ground rules are going to be, but I'm open to a conversation, any questions you may have about who we are, our agency. And first of all, thank you all for your service, for your sacrifices, whether it's past, present, or even in the future. Thank you for everything you've done to serve our nation. And so I want to talk about a subject that is very well known, probably to all of us. We've all had some kind of interaction with the VA, maybe when we were ETSing or retiring from the service, we had an appointment with the VA to have our medical records analyzed and to determine whether or not we receive disability compensation. I'll talk about that a little bit later on, but this is really where, after conversation with Melissa, we wanted to share information with you that we believe is useful in any context that you're in the employment context, that is. So I'd first like to introduce you to our agency, what it is that we do. So we are a neutral agency. We're a federal agency. We don't report to or fall under labor or justice. We are independent. And our vision, of course, is a respectful and inclusive workplaces with equal employment opportunity for all. Our mission is to prevent and remedy unlawful discrimination. So we are a neutral agency. We are in essence a federal civil rights law enforcement agency. We enforce federal anti-discrimination laws. I'll talk about those in just a few seconds. But we were actually created as a result of the civil rights movement in the 1960s by the work of course, such icons as Dr. King and other well-known civil rights leaders. It was determined that it was necessary to create an agency that would have the authority to investigate and enforce federal anti-discrimination laws. So that is where we come from. And I can tell you that moving up until the current time frame, our agency is staffed with personnel that are fully dedicated to this mission. You know, we talk about military and maybe the PowerPoint by death, right? The EEO training that we had to go through every year. This is a little bit different. Of course, it's talking about the same laws, but approaching it from a different perspective, the employment perspective. And so what is it that we do? I talked about that. We, of course, enforce federal laws. We accept charges of employment discrimination. We will investigate them, mediate them, conciliate them, litigate, educate, and more. So besides just investigating complaints of discrimination, our agency is very, I'll use the term, we're very aggressive in terms of even filing lawsuits against employers who we have found to have violated federal and anti-discrimination laws. And there's a process that we go through to get to that point. But the point is that we take our mission very seriously. And if we find that an employer is not complying, albeit intentional or unintentional, sometimes with the employers who just don't care, to be honest with you. But we do have a strong enforcement arm. And so besides just enforcement, besides just investigations, we also have the arm that I am involved with, and which honestly, I'm very passionate about. I am passionate about introducing our agency to organizations and to the personnel that are part of these organizations, such as yourselves, to understand who the EEOC is. Some people don't know who the EEOC does. Some people don't know what it is that we do. They don't understand our mission. They don't understand the laws. And more importantly, they may not understand the rights that they have under the laws which we enforce. So we also educate and provide training to the public about what it is that we do. And so we are located nationwide. As Melissa indicated, I am responsible for the jurisdiction of Southern Nevada and the Las Vegas local office, as well as the Pacific from Hawaii all the way out to Guam, American Samoa, Wake Island. These are places you all may be familiar with during your 10-year service, especially if you're in the Air Force and the Navy. But we have offices nationwide from Honolulu through the West Coast, throughout the nation, all the way out to the East Coast. And of course, the headquarters is located in Washington, D.C. Our jurisdiction that I fall under, we fall under the LA District Office, and we have 53 offices across the nation that all fall under the 15 offices indicated here. And so what are the protected categories? We all know this from our time in the service, right? We had to sit down through a half-hour PowerPoint presentation. Maybe it was a military EO rep or a civilian EO rep to come in and talk about EO laws, right? Some of us might have been like, oh, again, right? This requirement again. But it's really important to understand this. So our laws, the laws that we enforce, provide for 8 protected categories. The term that we use are the 8 protected classes. So so our laws indicate you're protected, or specifically that an employer cannot treat you differently, discriminate against you based upon someone's race, the color of their skin, national origin, religion, sex, and of course, sex includes sexual orientation, it includes binary, transgender, it includes all the LGBTQ plus categories, which the Supreme Court recently affirmed that are actually protected under sex. There was a time when someone might have gone into an office, it might have been a member of that community, and wanted to complain to the EEOC about discrimination based upon, for example, sexual orientation. And for a time, we would actually refer those personnel to state offices that had better protections. But during President Obama's administration, the EEOC took the position that sexual orientation, transgender, all these areas actually fall under the protection of Title VII or sex. And the Supreme Court recently affirmed that our position was correct. And so now it's more set in stone than it was in the past. And of course, disability, which is what we're talking about today. We're also protected if you're over 40. I'm 45. I hate to say that. I'm 45 years old. I've got gray in my beard. I like to think I'm still 20, but my body tells me otherwise, right? I'm not as fast as I used to be. Definitely not as skinny as I used to be. So, but our law indicates if you're over 40, you're protected under the Age Discrimination Employment Act. And of course, genetic information and retaliation. And we'll talk about retaliation a little bit later on as we get into the categories. In terms of, excuse me, I apologize here. In terms of retaliation, when people come to the EEOC, they complain about discrimination based on something. For example, just to make it very simple, I believe that I am being sexually harassed, or I'm being harassed because of my age, just to put it very simply. And so when the individual makes the complaint known to the employer, whether it's through a complaint through the organization's HR process, personnel process, maybe there's a toll-free line that they can call to submit a complaint, maybe they address the issue through their supervisor, their manager. The law states that to do that is protected activity. Every person has the right to complain or oppose discrimination within the workplace. That is your right to do so. But employers know they shouldn't retaliate, right? They know they shouldn't lash out, so to speak, because you have exercised a right to do so. The law states that you cannot retaliate against anyone who's complaining about discrimination based on a protected category. And so I wanted to just point, what protected activity is in case you come across it, or maybe you know someone that has come across it. So it is illegal to fire, demote, harass, or otherwise retaliate because an employee applicant has filed a charge, again, whether it's internally or externally, because they complained to the employer about discrimination, or because they participated in an employment discrimination proceeding. For example, maybe that person participated in an EEOC investigation. Maybe they participated in a state agency's civil rights investigation. For example, if someone requested an accommodation, which we'll get to in a little bit, or if they're associated with someone who did any of the above. And I'll tell you this, despite the fact that the law prohibits retaliation by someone who's complaining about these things, this has not stopped employers from retaliating. In fact, year after year, in the 13 years I've been doing this and been in this agency, retaliation is almost always at the top of the list by which people come to the EEOC to complain. They say, hey, Rogelio, hey, man, I complain about discrimination and I was fired, or I was demoted, or I was suspended, or you know what, I had my hours cut, or they begin to scrutinize my work even more closely. So these are all just small examples of retaliation that you might want to be on the lookout for. Something that I used to do as an investigator was to ask during the investigation was to ask the employer to provide me a copy of the complaining or charging party, as we call them, the personnel file, because we wanted to see the history of performance. And something that I could see at times was that the employee was an exemplary employee. They performed to standard or above standard. They exceeded expectations up until they complained. And then after you complain, as you take a look at the personnel files, I took a look at their the performance evaluations, the ratings throughout the years, all of a sudden the employee went from being a great employee, to being an employee who could do nothing right. Those things do happen. We understand that, right? But in these instances, it was evidence of retaliation, and the employer really couldn't provide a legitimate explanation as to why this employee all of a sudden is being disciplined, suspended, scrutinized, the work is being kicked back. You can all imagine the type of things that we're referring to here. And so who's covered, right? The question is, am I covered by the laws or not? And so the question here is yes. So if you're an employee if you're a current employee, if you're applying for a position, if you're a former employee, if you're a temp worker, right? When I think about temp workers, I think about Christmas, right? The holidays. I always think about, Target, the big retailers putting out ads for temp workers, or seasonal employees as they call them, right? So even if you're a current employer for 1-2 weeks, a month or two, you're still protected under the laws that we enforce. And when we talk about training and apprenticeship programs, whether you're an applicant for a program or a participant in the program, you're also covered. The laws stipulate that undocumented workers are also covered. Now, who is not covered? And this is extremely important. Volunteers are not covered. Interns are usually not covered, as well as independent contractors. And I know some of you may be consultants, right? And so there may be times you feel that, hey, I'm an independent contractor, but I feel as though the employer is really controlling my means and manner of work. They're not giving me, they give me everything I need. They set my schedule. I have control over it. So if it's that kind of thing, you're more likely an employee than you're an independent contractor. It could be an issue of being misclassified, but independent contractors typically are not covered under the laws that we enforce. And so what we would do as investigators is to conduct an independent contractor analysis about those things to see if you're actually an independent contractor or not. I'll tell you, as an investigator, I did actually conduct several of these analyses, and that there was actually, I think, very few times, but there were some times where the independent contractor was actually an employee for the purposes of that analysis. So who are the covered employers? So not every employer is covered. And so our laws indicate that there are stipulations, there are limits, right, to how we enforce the laws. How do we determine which employers are covered by the laws that we enforce? And so in most of our laws, with the exception of 2, you have to have the company has to have 15 or more employees. We're talking about the Age Discrimination Employment Act. We're talking about 20 or more employees. So if someone works for a state and local government, whether it's a state, city, county, those people are covered. Whether someone works for an employment agency, those people are covered. A union, of course, is covered in other areas. And so what's a private sector? Private sector is, of course, anything not government. It could be McDonald's, Lowe's, all those things. And so we have to understand that there can be third-party interference. There can be, other issues that I'm not really going to go into here, but there could be a situation where there's a joint employer. We've seen this some more with like staffing agencies, where you have a staffing agency who has dispatched someone to work for the company, and both the staffing agency and the employer are actually considered employers. They're both employers because they both have control over that particular employee that was dispatched from the staffing agency to work for the company. So there have been times where we find that not only the company that this person is working for is liable for discrimination, but also the fact that the staffing agency is also liable because they control the HR function, right? They control the personnel function in dealing with this individual. So timeliness. So when we talk about timeliness, there's a certain amount of time in which you have or someone has to bring a complaint to the EEOC for it to be considered timely. Now, these are things that are established by law, and these are things we cannot waive or we cannot change. So for our laws, for example, Title VII, the American Disabilities Act, the the Age Discrimination Employment Act, the American Disabilities Act, the Genetic Information Non-Discrimination Act. We're government and you're prior military, so we love our acronyms, right? So this is where this comes from. But if you're filing a complaint under these laws, then if you're filing in a state that has a state equivalent or a sister agency of the EEOC, what we call a Fair Employment Practices Agency. For example, in California, if you're in California, Texas, a lot of major states, you have 300 days to bring your complaint to the EEOC from the date of the violation. And so when we talk about the date of the violation is what date the action took place against you, right? Whether you were demoted, suspended, discharged, they failed to hire you, they laid you off, they failed to recall you, all those areas, you have 300 days in states that have the sister agency. Otherwise, it's 180 days. And so what's necessary to understand is that many times people want to go straight to court to file a lawsuit, but the law stipulates that in order to file a lawsuit under Title VII, ADAAA, ADAAA, and GINA, you first have to come to the EEOC as an administrative remedy to check off the box and then get permission, so to speak, to be able to go and file suit against an employer. Now, there's a separate law called the Equal Pay Act, and the Equal Pay Act is different because you have 2 years to file a complaint with the EEOC. And when we talk about the EPA, as we call it, it has to do with, of course, compensation, right? You hear the term a lot in the news by politics in terms of equal pay for equal work, and of course other very important areas that are out there. So what EPA refers to is that you're working in a position and you realize that someone who works with you or does similar work, maybe they have equal responsibility, similar skill, effort, and responsibility, and that other person is of the different gender or different sex than you are, and they make more than you do, then you can bring forth a complaint under the EPA because you're saying, look, we both do what I believe to be the same job. I'm a male, she's a female, but she's getting paid more, or vice versa, right? So I think this is a violation. And so you have 2 years from the date you discover this disparity in wages to bring your complaint to the EEOC. 3 years if the violation is willful. But unlike the other laws with the Equal Pay Act, you can go straight to court and file. You don't have to go to the EEOC, to check off the administrative remedy. You can go straight to court in this instance. Now, who can file a charge? The aggrieved person, basically that's you, right? That's individual. The complainant can file a complaint with the EEOC. Or maybe this person has an attorney, or maybe there is an organization, a nonprofit, right? Some kind of advocating agency can also bring a complaint forth on your behalf before the EEOC. So we call these third-party charges. In other instances, we have the commissioner. So within the structure of our agency at the very top, when you get to the top of the pyramid, so to speak, the top of the chain of command, right? We have commissioners, and these are political appointees who determine policy and the direction of the agency. And so a commissioner can actually bring a file directly under Title VII, ADAAA, and GINA matters against an employer. District directors, I mentioned the 15 districts that we have, can file a complaint directly against an employer in matters pertaining to equal pay as well as age discrimination. And so we ask, what kind of decisions are covered, right? What are the areas that are covered pertaining to the EEOC? What can I bring my complaint to you about? Basically, anything to do with employment, any job decision, any job action is something you can bring to the EEOC. For example, you see these here, and I'll go through some of the hiring, right? Firing, left, not recalled to work, pay, talked about that already, assignment or classification, transfer, denial of promotion, some kind of unfair job testing or policy, recruitment and job ads, reasonable religious accommodations, segregated use of company facilities, training and apprenticeship programs, benefits, whether it's fringe benefits, retirement benefits, disability leave, and other terms, conditions, or privileges of employment, harassment, and much, much more. I want to talk about harassment because we all understand that someone with a disability can be subjected to harassment, right? We've all seen the stories, we've all read articles, we've seen social media postings, you know, whatever the case may be, about someone who is disabled suffering harassment at the hand of coworkers, being ostracized, being mocked or made fun of, being called some kind of name because of a physical condition that affects us. Maybe someone has an unseen disability, right? For example, I'll be very transparent with all of you. Like I said, like I said in my bio, I am the father of three kids, and my youngest he's 13, but he is autistic. He is moderate on the spectrum. He is nonverbal. He does not socialize. He is not independent in any sense of the word. And so, but when you look at my son from the outside, you would have no idea that he is, of course, that he has autism, right? And so we understand there are other unseen disabilities. When I think about the community that you are a part of, that we've all served, and the things that we have experienced and the things we've gone through, whether it was multiple deployments or high op tempo, whatever the case might have been, right? Many of you, many of us maybe are struggling, have been diagnosed with, or being treated for PTSD, right? And there's something that's not always seen, right? You can't see that from the outside by looking at someone. It's not physical. It's not like someone who may walk with a support such as a cane or a walker or some other physical ailment that can be clearly seen. And so I want to address harassment and what that means within the employment context, right? Not the social context. Of course, it's important. I'm not trying to downplay that, right? But I'm talking about the employment context. And so harassment, it has to do with unwelcome conduct, comments that are based on a protected basis. So when we talk about a protected basis, I'm talking about the protected categories, right? The race, the color, national origin, sex, disability, age, genetic information, right? The things that we talked about. And so anyone can be the object of harassment, and anyone can be a witness to the unwelcome comments or the conduct. And there is no stereotype for what a harasser is. You know, I think the days are gone of the belief that only, for example, that only men sexually harass women. Back in the day would have been a man being sexually harassed by women. Come on, man, give me a break, right? But we all know we live in a very different time now. Understanding that the harasser can be the same or different protected bases. It can be male on male sexual harassment. It can be women on women sexual harassment, for example. And the harasser can be a supervisor. It can be a coworker. It can be a non-employee. It can be even a third party. Now, what is a third party? A third party has to do. You're like, well, what are you talking about? I'm talking about FedEx people. I'm talking about UPS, the ones that come to our agency, to our organizations, to maybe service the printer, the copy machine, the contract. You know, there's a service contract in place. These are third-party harassers. So if you have, for example, the UPS delivery person comes in the door and is constantly sexually harassing, for example, the receptionist or the office manager, right? There is something that can be done, right? There's an obligation by an employer to protect their employees from harassers, whether that be internally from within the organization or externally from customers, contractors, these types of groups. Now, what happens after a charge is filed? Well, you know, I just go through the whole chart here, and I'll be providing a copy of these slides, excuse me, I apologize, to Ms. Washington. I'll mail it. I'll make it available for all of you, and she can distribute as she sees fit. But basically, we take the complaint, and after the complaint is taken, then there's an option, invitation to mediate. So mediation is what's known as ADR, alternate dispute resolution, by which we invite the complainant and the respondent, or the employer of which the person is complaining about, to participate in the EEOC's mediation program. It is voluntary, it's free and confidential, and about 80% of the time within our district, it is successful. So it's a quick way to resolve it and a quick way to put the matter to rest. Now, because it is voluntary, if you go to mediation and it works great, if you go to mediation it doesn't work, or if one party says no, right, says no to the invitation, then it goes to investigation. And we are neutral throughout the process. We do not represent the complainant. We don't represent the employer. We operate in the public interest. We take a look at the facts of the case, analyze those facts in light of the law, and then make a finding as to whether there was sufficient evidence to establish discrimination or not. If we look to the right of the chart where it says insufficient evidence, if after investigating, we find that there was not enough evidence to establish a violation, then that person is made aware of that. We give a brief explanation as to why, and then we issue that person what is called a letter of dismissal and notice of right to sue. So despite the fact that the EEOC has made this finding, that individual retains the right to file a complaint in court on their time, at their expense, against the employer. That's their right. What the court does is completely out of the EEOC's hands of jurisdiction. Now, if after investigating, we find that there was a violation, then of course we notify all the parties and go to a process called conciliation. Something that I want to share with all of you is the fact that conciliation is a voluntary process. We cannot fine like Department of Labor does. We cannot make anyone do anything. It is a good faith negotiation to try to resolve. Sometimes it works, sometimes it doesn't. We do our best. Now, if conciliation fails, right, then we refer to a legal unit. The attorney decided they want to sue or not, and they will either sue or will issue the right to sue letter. And of course, understand the entire process is free. Whether we're able to negotiate monetary relief for someone, it doesn't matter. We don't work a commission, we don't take a pay cut, we're civil service employees, and that person gets all of the money that's negotiated on their behalf, or sometimes a group of people. Remedies, we're able to obtain a lot of these things. I'll skip over this because I want to go further and more in detail. These are resources that you can look into. Now I want to talk about who's protected by the Americans with Disabilities Act. Now, it was initially established in 1990, and what it does is to prohibit employment discrimination against qualified individuals with disabilities. And so I want to talk about disabilities just a few seconds, but I know that some of us, maybe all of us, are receiving some kind of disability compensation. Maybe when we ETS or retired after a appointment with the VA, maybe sometimes the result was quick, maybe not, right? But we were all issued some type of, or maybe if you went through the process, you were assigned, so to speak, a disability rating, right? And based upon that rating, it determines how much monthly compensation you receive, whether you're 10% disabled, 20, all the way up to 100. And we all understand the VA and the ratings and how they work. But what I want to make very clear with all of us is that just because we are receiving a disability rating from the VA, it may not necessarily mean that you have a disability under the ADA. More than likely, that will be the case, but we examine these things on a case-by-case basis. So this is what I wanted to share with you, that yes, if you're receiving disability compensation, it is not automatic that under the ADA, you'll be considered a qualified individual with disability. So allow me to begin by defining what is a qualified individual. So it is someone who has the skill, the experience, the education, and other requirements of the position held or desired. In plain speak, that you're qualified in every sense of the term for the position you're seeking or for the position that you're holding. right? You have to be qualified. And that besides being qualified, right, that you can do the essential functions of the job with or without a reasonable accommodation. You're like, Rogelio, what is an essential function? Plain speak, it is a primary, it is, think about it as the core duties and the reason by which that position exists. If it were not for those core duties, that position would not exist. It's essential, right? There's a list of core functions at the heart of every job description by which that position exists, right? So that's essential functions. I'm not talking about other duties as assigned, as we saw in the military. Maybe your civil service, and we've seen that term used a lot, right? No, it has to do with the primary functions of that position. And you can do the primary duties of that position either with or without a reasonable accommodation. Now, what is a disability? We talked about disability in the context of disability rating compensation, but I want to talk about it within the context of the American Disabilities Act. And it is one of three things. It is a physical or mental impairment. We talked about, right? Physical, the things we can see, right? Or mental, the things that we cannot see. That substantially limits a major life activity, right? A disability is also is that there's a record of such an impairment, right? There's a notation in your file. Maybe there's a doctor's letter out there that outlines what your diagnosis is, right? It's not a note that we go to the doctor and here this person can sue in this date and that's it. That's not defining disability. The employer has to be on notice, right? The employer has to be aware of what your disability is. I'm not talking about disclosing it right now. I'm talking about within the law, the employer has to know what your disability is. And third, that maybe you're being regarded as having such an impairment. This last one's kind of interesting because many times we have people come to us and say, hey, I'm being told, I'm being treated as if I'm disabled, but I'm not disabled. They're making these assumptions about me. So you've been regarded as having such an impairment. Now, in 2008, the law was amended to include, it's the American Disabilities Act as amended. And so the definition of disability is broader now. Back before 2008, we spent a lot of time analyzing whether someone was actually disabled or not. But now, with the law being amended back in 2008, we spend more time focusing on the merits of the charge. And so mitigating measures will now be considered. A condition can be episodic or remission. We talk about cancer, epilepsy, and of course, temporary non-chronic impairments of short duration will not be considered disability. So if someone has a sprained ankle, sprained knee, appendicitis, common cold, that is not considered to be that's not considered to be a disability. Now, major life activities, which is another function, which is another part you saw in the definition, it has to do with something that we do every day, where we talk about all these areas, right? We all perform manual tasks. We see, we hear, we eat, sleep, walk, stand, lift, bend, speak. We all breathe, we all learn, read, concentrate. All these are considered major life activities. And it has to do with the operation of a major bodily function. For example, you see the examples here, the function of the immune system, normal cell growth. Well, what condition affects normal cell growth? We're talking about cancer, right? For example, digestive bowel issues, bladder issues, all these functions you see here are considered major life activities. So it's having a physical mental impairment that substantially limits major life activities. So our condition, our disability limits us or substantially limits us in these areas, right? Being able to see clearly, hear clearly, walk normally, you know, as others would walk, stuff like that. So let's talk about substantially limited. So how substantially limited does impairment need to have it on a major life impairment? Well, it's a common sense assessment, right, of a person's ability to perform a major life function when compared to someone in the general population. Now, there are issues that arise in the hiring process, and I want to share these with you because we see this quite a lot. So I want to share with you the things that an employer can do before they hire you and after they hire you. So before hire, an employer cannot ask if you're disabled. They cannot ask you what your disability is. They cannot say, hey, I see you put on your resume that you served in the Navy for 18 years. Are you disabled? That is an illegal question. They cannot ask you that. They cannot ask information about your genetic information or family medical history. They cannot ask about the nature and severity of your disability. They cannot, before hire, require you to take a medical examination. And they cannot deny a request for accommodation during a job interview if there's no undue hardship. So someone cannot take one look at you or look at us and see that we walk with a cane and assume that we can't do the job, so they're not going to hire us. Or they can say, hey, I see you walk with a cane. What's your issue? What's your deal? Right? What are you doing? Right? So, oh, you know what? I want you to take a medical examination, but you haven't even hired yet. All those things are off limits. They cannot do that. But they can ask these things. They can ask us, can you perform the duties of the job with or without a reasonable accommodation? They can show you a copy of the physical requirements of the position. They can describe it to you and ask you, well, these are their main duties, or these are the requirements of the position. Can you do them? They can ask that question. They can ask you to describe or demonstrate how, with or without an accommodation, how you perform the duties of the job. So after a job offer, an employer cannot do these things. They cannot require you to take or undergo a physical or medical exam as a condition of employment if all employees for that job category are not required to do so. So if no other employee in your job category is required to undergo a medical examination, the employer cannot force you to do the same just because you're disabled. They cannot do that. They cannot reject you for employment due to results of a medical examination unless the reasons are job related and necessary to conduct business. So let's say, for example, you're extended a conditional job offer, and a lot of times it's contingent upon the results of a physical exam or medical examination, sometimes a psych test, depending on the field you're in, and other things. And let's say, for example, that during the medical examination, it was found you have high blood pressure, right? Then they cannot fail to hire you just because you have high blood pressure unless there's legitimate job reason to not be able to hire you because you have high blood pressure. And also, they cannot ask any information about your genetic information or family medical history. And so this is interesting because not many people may know this, but when you're undergoing the employer's medical examination, at times they do that externally. They refer you to one of the doctor they contract with, and then you fill out, like we always do, you sit down in the waiting room, they give you a clipboard and you start filling out, all these questions: name, insurance, date of birth, right? And there's a long checklist of, have you ever, been pregnant, bam, 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 right? And then you come to a section where they start asking about family medical history, right? They start asking, well, does anyone in your family, did they ever have diabetes? Did they ever have high blood pressure, right? They start asking all these questions, and we're so conditioned to just fill it out, right? Or like, oh, and we just check it off or exit off, whatever the case may be, right? So the employer may not ask for that information, okay? But even if they do obtain the information, they cannot make an employment decision regarding your application or hiring process based upon your family's medical history or your genetic information, right? When we think about genetic information, it sounds complicated, but it's really not, right? When we think about our family histories, we think about those who came before us, our grandparents, great-grandparents, our moms or dads, right? Whatever the case may be, right? It's always believed that, well, if someone in my ancestry had high blood pressure, and my grandfather had high blood pressure, and my dad has high blood pressure, I don't have it now, but genetically speaking, there is the potential for that to manifest in my life at some time if I'm not careful, right? So, or where the case may be. So they cannot use that information against you because someone in your family has had those conditions and you have the genetic potential to deal with those conditions. Think about genetic information as a condition that has not been manifested yet, right? This is the best way that I think to explain it. Also, after a job offer, an employer cannot disclose information about your disability to others, except for certain people. They can disclose it to supervisors. They can disclose it to decision makers, safety personnel, insurance, the government. An employer cannot commingle or mix documents pertaining to disability with other personal documents. It must be kept in a separate file. In fact, we've issued violations against employers who we've asked for a copy of that person's medical file, a copy of their personnel file, and guess what happens? At times, it's on one file. It has to be kept separately. Any medical information, any information about your disability has to be kept separate from your personnel file. Now, let's say that you request an accommodation. I'll talk about this in just a few minutes. They cannot fail to engage with you in the interactive process. I'll talk about that with you regarding any reasonable accommodation request. So what's an accommodation? I want to talk about, oh, I apologize. There may be a moment, there may be times that you may need to request a reasonable accommodation related to your disability. Now, an accommodation, what it does is to make facilities used by employees really accessible and usable by persons with disabilities. And it's also defined as any other change or assistance to assist the employee with a disability and doing their job duties. So let's say, for example, that you work in an office environment, you work at a computer, right? And you have vision challenges, you have a disability regarding your vision. And so you go to the employer and you request, I'm requesting magnification software for my computer because of my condition. I have an issue that I cannot see very well and I need it magnified, and no matter how much I've tried to enlarge it within the function of the computer or my monitor, I can't see very well. I'm requesting to be provided with software. That's a request for accommodation, right? It could be a change in how an employee does their job, right? It could be where the job is conducted. It can be related to work hours, work schedule. There are many different things that come into play when we talk about reasonable accommodation. For example, if someone is deaf or if someone is mute, then they may say, well, I need an ASL interpreter, right, to be able to understand, to be able to do my job. And so these are requests for accommodation, and the employer cannot outright deny your request. You heard the term in the previous slide about interactive process, and the interactive process has to do with a conversation that has to take place once an employer becomes aware of your request for accommodation. Now, when you request an accommodation, you will have to disclose your disability. You cannot say, I can't tell you. You have to disclose it. You have to tell them what that condition is, right? And how it affects you. And so they receive the request. You don't have to use that term, right? But if you use the term reasonable accommodation, that's great. You don't have to use it. But once the company is aware that you need accommodation because of disability, right? Then they have to engage in the interactive process with you. They have to speak with you. They may need to speak to your physician, to the mental health specialist that you're dealing with, or your nurse practitioner, whoever is providing your care may need to provide additional information. The employer may request relevant medical documentation. Now, they cannot request your whole medical file, but they can request relevant medical information from your doctor to be able to process your request. So the question then becomes, is the employer required to provide a reasonable accommodation? The answer to that question under the ADA is yes, unless that accommodation causes undue hardship for the employer. And many times when we talk about undue hardship within the context of the ADA, many times we're referring to cost. How much is it going to cost the company to pay for this reasonable accommodation? I understand that the applicant, the employee, is not required to pay for reasonable accommodation. Understand as well that whatever software devices are issued to you are for work purposes only. They're not for personal use, and they're not for us to keep, right? It's within the employment context. Now, the question is, does the employer have to give me the exact accommodation I'm requesting? And the answer to that question is no. The employer does not have to provide the preferred accommodation. The law stipulates the employer has to provide what is to be an effective accommodation, right? But the accommodation does have to meet the needs that you have as a veteran, as a person with a disability. Now, if more than one accommodation applies, there's different options they can offer you, then they can choose, right? So again, they don't have to give you exactly what you're asking for. The law only states that it must be effective, and at some point it can be revisited. So, employer's decision. The question is, can the employer refuse to hire because of the applicant's disability or the need for accommodation? And the answer to that question is no. But they can refuse to hire you if your disability prevents doing the essential functions. Remember, I emphasized the primary duties, the core duties earlier, right, about a position. So if the disability prevents you from conducting the essential functions of the job, then you're not qualified for the job, right? You have to be qualified for the job. And the employer can hire you if your disability poses a significant risk of substantial harm to the applicant or to others. And with this, I just want to share with you a case that we had some years ago as an agency regarding disabled individuals. We obtained a $240 million jury verdict for 32 intellectually disabled workers that were housed in this facility. As you look, that is the one in Iowa. They were paying $2 a day for 20 to 30 years. They housed these individuals in squalid conditions. Many had ended up with more medical conditions. They were hit, they were handcuffed, and kicked by supervisors. It is, what happened to these individuals was horrible. The company is no longer in business. But I want to share with you how seriously the EEOC takes disability. Now, I am open to questions. And what I'll do is to leave this up, my next slide up, for contact information. Again, I'll be distributing these slides to Ms. Washington. But Melissa, back to you for questions of follow-up. How else can I be of service to this group?
Absolutely. So we do have a question here in the chat from Kimberly. She is asking, what is the guidance to employers making these decisions? It seems like this decision is left up to employers who have no understanding of disabilities.
And Kimberly, you're exactly right. A lot of employers are really, there are many employers who are ignorant, so to speak, as it pertains to disabilities. But we do have ample guidance on our website. They should have access to attorneys that should be able to provide them with information. They're also free to reach out to us as outreach education coordinators for any technical questions that may be had about disabilities. And so there's information out there. A lot of times it's just about education, Kimberly. It's understanding what the ADA states. Like you said, a lot of people just they don't know. And sometimes, there may be a situation where they're given bad advice by someone and it doesn't work out. But all they have to do is contact the EEOC. There's ample information to guidance on our website. Reach out to someone and ask for help. And we'd be glad to assist them to understand the requirements of the ADA.
Thank you, Rogelio. We have another question from Amy. How do we handle employees with dyslexia?
Well, Amy, that's kind of a broad question, but if it's an issue of employees that have dyslexia, those employees may need to request an accommodation. I'm not quite sure how that ties into what their exact job duties are, their functions. I guess a broad question. But if an employee has dyslexia, they can request an accommodation that may assist them. Maybe they would need additional time. I don't know, there's some kind of software out there that maybe it's a system. I actually do not know. I honestly don't know. But allowing the employees the opportunity to request an accommodation and the employer working with them to see what accommodations are available to assist these employees that are, you know, that are struggling with these issues.
Right. Looks like that was the last question. Kimberly, follow up. Do you believe there is a clear guidance on ADA in the DOD?
The DOD is required to obey, well, sorry, I'm not gonna use that term. They're required to comply with the requirements of ADA as well as the Rehabilitation Act. There are many EO counselors, reasonable accommodation managers that are trained by the EEOC. We actually have an entire team dedicated to federal sector matters. So I can't opine, but I can tell you there's information available also to these individuals. If they follow the training they've received, and they can also reach out to EEOC for technical assistance if there are any doubts about it. Kimberly.
Okay, thank you.
Thank you, Kimberly.
All right, well, that looks like all the questions. Thank you so much, Rogelio, for a very thorough presentation, and everybody's got your contact information here. So if you need to reach out to Rogelio directly, please do so. And again, thank you so much for your time and sharing this information with everyone.
My pleasure, Melissa. Thank you again for the invitation. We actually appreciate it.
Thank you, everyone.
Okay, have a good day.